Good day, Crime Talk aficionados. It is Sunday, and what does that mean? It means it is time for the weekly recap of all the top stories that we discussed throughout the week, conveniently located in one particular place. Thanks for watching. We'll see you next time, and remember, the Constitution matters.
All right, lawyer.
Next, Jennifer Crumley case. That's right, Ethan Crumley, obviously, the prosecutions say that he needed his mother's guidance, some understanding from her, some recognition that maybe things weren't right in his life. And the prosecution said, well, she gave him a gun instead. Now, Jennifer Crumley and her husband obviously gave Ethan access to a firearm. And whether it was early Christmas present or for their kid that had some mental health issues depends on, who you're talking to, I guess. Needless to say, a jury found her guilty of 4 counts of involuntary manslaughter last February. And needless to say, I'm sure she would love to take back her actions, but she cannot. But throughout this ordeal, obviously people found her to be completely dislikable, thought that she was not a good mother and not very sympathetic as a defendant either. So, can we blame the prosecutors, though, whose pretrial's actions prompted potential concerns from the judge last Friday as it relates to Ms. Crumley's appeal? Possibly. That's right, we can. As I've said before, I think the Jennifer Crumley conviction is horrible. Now, don't get me wrong. She is not going to get the Mother of the Year award. Both she and her husband failed as parents. I truly believe that. But I don't think being a bad parent is necessarily a crime, okay? They could have said, here's your new car as an early Christmas present, and he could have driven it through the crowded parking lot and killed even more people. Would we have said they were going to charge her then? No, I think it had to do with the instrumentality, in this particular case, obviously, a firearm. But the concerning part here is the conduct of the prosecutors. And this is when the prosecutors go after this win at all cost mentality. Remember, a prosecutor is supposed to serve justice, right? Justice is the result, not to win. And if they don't think they can prove the case, then they shouldn't go forward with the case, particularly when it's a unique, novel idea. Obviously, the first parent ever charged for conduct of a child in a school shooting. Needless to say, what we found out through the course of defense motions and the hearing was that the prosecutors offered proffer agreements to the Oxford High School counselor, a guy by the name of Sean Hopkins, and the former dean of students, Nicholas Ejak, E-J-A-K, who met with the 3 Crumleys just hours before Ethan went on his little shooting rampage. But the agreement guaranteed that the statements made by Hopkins and Ejak in their proffer meetings would not be used against them. Basically means they would have no case against them. But as it came out last week, the attorney for Jennifer Crumley said, guess what? The prosecution never told the defense about those particular agreements. Clearly, the judge was not pleased. Because guess what? It's probably information that should have been turned over. I'd say absolutely should have been turned over. And I would give the Crumleys a new trial because of this prosecutorial misconduct. You may not like it, but you can't hold something like that back. And that's why routinely, we get admonished by judges. Why do you file these motions? Because, Judge, I'm covering my butt. I want all agreements made by witnesses, co-conspirators, anybody else, any offers of leniency whatsoever. And guess what, ladies and gentlemen? Why didn't they go after the school counselor, the dean of students? They're the ones that actually spend more time with Ethan Crumley during the day than the parents do. You would think that they should have filed charges against them if they're going forward on this unique legal concept. But the prosecution picked the people that they didn't like. There were ones that, we could try to hold accountable, mom and dad. Anyway, the prosecutors are like, well, we didn't really have to turn that over. And the judge is, I think, not happy. And I think that the bigger issue is going to be she's going to have to grant a new trial. I really do believe that. But then there came another little issue. There's apparently a family connection between the chief prosecutor, a guy by the name of David Williams, and the executive producer of the Hulu documentary, whose crew practically lived in the prosecutor's office during the Crumley trials which were obviously subject to a gag order. We know that before the Crumley and her husband, James, became first parents in the United States held responsible for gunning down classmates, Williams did particularly gracious favor to his wife's cousin by marriage. That's right. If that seems a little like a family link, I don't know what is. I think that's a problem. Now, when the documentary came out, Sins of the Parents, the Crumley trials, and it aired only 9 days after the Crumleys were sentenced to 10 to 15 years in prison, Williams' concern was the timing, not its content. Now, in an email, the producers tracked down by some press wrote, during the filming, we were under the impression that the documentary would drop months after the verdicts and sentencing, not days. We were stunned to have the trailer drop on Good Morning America and in Times Square less than 72 hours after the sentencing. Well, needless to say, some prosecutors even think that that's a little weird for that to take place, particularly if the other side doesn't know about it. And then on top of that, that's right, the prosecutors spent over $100,000 for a PR campaign to basically disparage the Crumleys in the press, not only locally, but nationally as well. So the prosecutors were engaging in a coordinated media attack against the defendants. Yeah, that's kind of icky and gross too, don't you think? So, as the defense was arguing, what the prosecution case lacks is in the law. And basically, everybody knew it. So the prosecutors attempted to make up for their lack of legal standing as it relates to a good, solid case, not their ability to bring the case, in the court of public opinion. That's right. They tried to sway everybody else that these people were absolutely terrible to go forward with this. And I dare say for political reasons, because it's the politically expedient thing to do. Somebody's got to be charged. We must do it now. We don't want cooler heads to prevail. No, we want somebody charged now because it'll make us all feel better. Anyway, the Crumleys were an easy target, were they not? They were. Anyway, we'll have to wait and see what the judge rules. I hope she gives the Crumleys a new trial, ladies and gentlemen. For the lack of disclosure by the prosecutors as it relates to basically immunity agreements and the fact that there was a coordinated campaign against the Crumleys when there's gag orders in place, hiring somebody else to do what the prosecutor couldn't do themselves. And then on top of that, the documentary team literally living with the prosecutors when it's not disclosed what was taking place. It stinks, ladies and gentlemen. You may not like it, but even if you think the people are terrible, you got to give them a fair trial. That's right. A former healthcare executive is making the case for the ultimate punishment for Luigi Mangione. Now, who is this former healthcare executive? Well, it happens to be present Senator from Florida, Rick Scott. And he wants Luigi Mangione to receive the death penalty for allegedly shooting the United Healthcare CEO, Bryan Thompson, which ultimately killed him. Now, the senator from Florida calls the actions reprehensible, and the reaction to Thompson's death was extremely polarizing among the political community, with liberals saying it points to America's unhappiness with the U.S. healthcare systems, and conservatives calling the murder an injustice against the system. I think everybody would say it was cold-blooded, and the shooter, giving Luigi Mangione the presumption of innocence, shot the man in the back, shot Bryan Thompson in the back on an open street and then fled. How is that not first-degree murder? Anyway, Senator Scott is a former healthcare industry executive, said that Mangione has not been convicted of Thompson's murder, but he does believe that the death penalty should be justified if he is in fact found guilty. Now, Senator Scott said it's obvious that the death should be the punishment due to the cold-blooded nature of the murder and the obvious vendetta that he held against the CEO that he had never met and frankly wasn't even a customer of the company. Anyway, Luigi Mangione, in the beginning, back in December, allegedly shot and killed the United Healthcare CEO, Bryan Thompson, in Midtown Manhattan early morning. Scott says that in the way that he was executed, it seems obvious at that moment that the world would condemn his actions. But the senator said there's been a big push, at least in social media and the sort of the younger generation, trying to almost defend or excuse Mangione because of the problems that he sees in the healthcare industry and the insurance industry in general. The senator did say, when asked a question about his reaction to the people supporting Mangione, he says, listen, there's a group that believe in violence now as a way to get change, and they want you to know that you just have to condemn it and hold those people accountable for bad acts. And when ultimately asked point blank by a host to Senator Scott whether he thought the death penalty was appropriate, he said, quote, I mean, he's not been convicted yet, but it sure looks like it was just absolutely in cold blood, and he just had a vendetta against him. So at least that's what you got to read into it, Scott said. So if that happens, is it death penalty justified? And Senator Scott said, if somebody doesn't like the way the healthcare system is being delivered, then you get in the middle of it and you change it. That's the right way of doing things. You don't go around killing people, right? We've talked about it. They've only got two defenses. They got to go some sort of heat of passion or some sort of mental health type defense in that particular case. Just as a note, why the good senator from Florida, Senator Scott, may feel this way is, guess what? He co-founded the Columbia Hospital Corporation, which later merged with another group to form Columbia HCA, and it became the nation's largest for-profit healthcare company. HCA, which is Hospital Corporation of America, remains the number one largest hospital system in the U.S. by revenue, and United Healthcare is the largest healthcare insurance company in the United States. So take it for what it's worth, ladies and gentlemen, but that's the one side. We have some people that want Luigi freed and given a medal of national medal for heroism, I guess. And then on the other hand, you have people thinking that you can't go around killing people if you don't like a company's business practices. You all decide what you think is appropriate. We're just bringing you both sides of the argument. Next, Lori Vallow doesn't want her trial streamed. Can you imagine that? That's right. Lori Vallow filed an objection to the media coverage in her upcoming Arizona trial. And Lori Vallow alleges that the Court TV, the one who wants to stream it, falsely characterized, libeled, and slandered her and her husband, Chad Daybell. And Lori Vallow is obviously charged with the conspiracy to commit murder in the death of her former husband and the attempted murder of her ex-nephew, Bryan Boudreaux. Anyway, so let's go exactly to her motion. And if you notice up here at the top, she apparently has her legal team, her pro se legal team, paralegal, because they paralegal at the top put that it was for another case. I think that's rather interesting, for another defendant. But they got the caption and everything correct. Anyway, Lori Vallow objects to Court TV's request to show her trial because of the bias they have already created in the community. She cites that Lori Vallow and her husband, Chad Daybell, are the commercials for Court TV, that these commercials run constantly throughout the day, and they have falsely characterized, libeled, and slandered Miss Vallow. She notes that Court TV should be ashamed for its very nature of its request, since its sole objective is to not bring people real news or facts, but instead its objective is to entertain the public with the very true life tragedies that happen in real people's lives. She says the defense objects to Court TV being allowed in this court to participate in the judicial process, including their request to appear at trial, live stream the proceedings on the web, and distribute the live feed. Needless to say, as I noted, Lori Vallow is now representing herself for the trial that's going to involve the death of her husband. That'll scheduled to begin next month on March 31st. No trial date has been set for Brandon Boudreaux's trial, but it is anticipated that it'll either be dismissed or go immediately after the homicide case, since she is demanding her speedy trial. I am of the belief that this trial should be streamed. It is of great public interest. We need to be able to hear the facts, see what evidence is presented. That is how the truth comes out. So, sorry, Lori, but your motion should be denied. Next on the docket. First, time that photos have been released outside of what was shown in court has been released to the public. Let me explain. So we've talked about this. There was a motion from Richard Allen's defense team that prompted a response from the prosecution and led to the release of some crime scene photos that have never before been seen outside of court. So back in November, a jury convicted Richard Allen of the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge. Now, the Judge Francis C. Gull, sentenced Mr. Allen to 130 years in prison this past December. Well, last month, Allen's defense team filed a motion to correct errors, maintaining their client's conviction should be vacated, and the defense cited a purported confession from another man and the disputed timeline of the passing van to prove the key witness in the case, or one of the key issues in the case. Anyway, another factor brought up by Allen's attorneys was expert testimony from a defense witness who said activity logged from Libby German's iPhone 6 showed someone had inserted or removed headphones from the auxiliary jack. As we've talked about before, all of that information is kept in the phone and recorded. You turn it on, you turn it off, it goes silent. Somebody plugs something in, you hit play. It's all in the phone activity. It's amazing everything that's saved in there. Anyway, this logged activity happened between 5:44 p.m. and 10:32 p.m. on February 13th of 2017, the day the girls were killed. That testimony came from Stacey Eldridge, a digital expert in forensic who took the stand for the defense. In response, a Sergeant Chris Cecil, an Indiana State Police phone expert who testified for the state, said it was possible water or dirt may have been responsible for the activity that was logged in the history of the phone. Anyway, Cecil told the court that he had performed a Google search during a court break before offering his opinion. Now, in his response to the defense motion, the prosecutor cast doubt on Eldridge's findings, saying she didn't file a report, log, or other information to support her testimony. Now, the prosecutors also noted the bulk of her expertise was in computer and network forensics, not cell phone forensics. Well, these cell phones are pretty much computer. Anyway, McClellan, the prosecutor, wrote that investigators didn't find any headphones at the murder scene. He also found it very unlikely that someone returned to the crime scene at 2:32 p.m. the moment the phone stopped moving, removing the phone from underneath Abby Williams' body, where the phone was later found, plugged in headphones, kept them plugged in for 5 hours, and then placed the phone back under Abby's body, all without logging any movement in the history of the phone. Anyway, the prosecutors wrote that Eldridge didn't examine the phone herself and could not determine whether the phone sustained any water damage at all. In support of his response, the prosecutor included multiple photographs as exhibits, 3 of them, the state's exhibits 9, 10, and 11. And it shows Libby German's phone, her iPhone 6, at the crime scene. And the photos were shown at trial, but the court's observers and the jury were able to see them. Only court observers and the jury were able to see them. Now, the photos appear to show the phone screens covered with droplets of moisture, and the phone sat among sticks, leaves, and what appears to be dirt. The phone was absolutely central to the Delphi case. Libby German used it to record the 43-second video showing the girls encountering the bridge guy, and activity data also showed the phone stopped moving at 2:32 p.m. on February 13th of 2017, which the state believes marked the moment that the girls were killed. Now, Cecil did see photos of the phone showing the condition in which it was found, and he based his conclusion in part on those photos, along with how long the phone had been outside and his knowledge and experience of forensic phone examination. The prosecutor said the defense could have called a witness to rebut Cecil's testimony about the impact of dirt and water. They chose not to, so you don't get to do it post-trial. McClellan also noted that none of it constituted new information that would overturn the result of Allen's trial. In fact, the information came from discovery material, and he believes it should have been brought up during the trial to challenge Cecil's testimony. As such, the prosecutor said the phone evidence and the other issues raised by the defense didn't constitute a basis for a motion to correct errors, and asked the court to reject the defense motion without a hearing, which I'm sure Judge Francis C. Gull, a.k.a. Special Judge Francis C. Gull, will do, and then we'll go up to the appeal. So you may recall several weeks ago, after the motions hearing in the Bryan Kohberger matter, I said I believe that behind the scenes, the defense is going into mitigation mode and they're trying to cut a deal. And that deal would probably include pleading guilty to all 4 counts in the Bryan Kohberger case, as well as the burglary count. In exchange, the state would drop the death penalty. Now you may say, Scott, what has changed your mind about that now? Well, first, we know that there are a couple of things. We know, obviously, Bryan Kohberger is the suspect in the quadruple murder for the University of Idaho students, right? And we know that he has a trial coming up this spring and summer. And we know that the judge has denied many and is going to deny more motions against the defense. And so now the defense, things are getting serious. They either have to start seriously going into trial preparation mode, and they also are in the mode of trying to cut a deal. What is the deal? Usually in death penalty cases, it's save my client's life. That's what the goal is. Yes, you would love to win the case, but that is a big table that you have to run to get there. Very, very difficult because the evidence is usually pretty significant if the state feels they are going to go with the death penalty. And so how do we know that that could be taking place? Well, we know for a couple of reasons. And the first one is, obviously, first reason is that what I just mentioned, things are getting serious now. But second, there is a protective order. And a protective order is an agreement or an order by the court saying very limited people, and it normally involves the attorneys on both sides and any investigators or professionals engaged in the case on both sides, gets to have access to certain things, and that they cannot disseminate that information to any party that's not directly involved in the case. So the protective order says you must not reveal this information. If you do, you can be subject to contempt. And what do we know? The judge unsealed a protective order in this particular case. Even though it was originally sealed, the judge basically said that there is no compelling basis to keep this protective order in and of itself sealed. Now understand, the contents of the records of the protective order are going to remain confidential, and that's fine. But what we do know is these are mental health records that were initially handed over on January 9th of this year, almost 2 months after Judge Stephen Hippler ruled that Bryan Kohberger can face the death penalty. So why would the defense be turning that over? Once again, mitigation. Here's all the reasons. Look at my client's mental health history. Here's issues maybe family has had. Something's not wired right. Somebody's broken. Please consider this. Take the death penalty off the table. Or the second reason is defense experts are going to rely upon this, and they have to turn this information over to the prosecution because it forms the basis of their opinion, whether it's for the defense case in chief or ultimately for mitigation if it gets to sentencing. I do believe it is for mitigation purposes. We'll have to wait and see. Like I've said in the past, I've only done one death penalty case, and frankly, we got them to take death off the table. So it can be done, but it's a mitigation mode. You're saying, spare my client's life. You can't get a death penalty because of all this mitigation. So let's just cut to the chase. Either take it off the table completely or let us plead guilty to the charges and take the death penalty off the case. This is why it's so important for the courts to disclose this information. I understand there's a reason to keep certain records private, but we should know, the world should know what is taking place, and then we can figure out what it actually means, which is going on in the case. The public has a right to know. So nice job for the judge allowing this protective order to be unsealed.